I'm Bill Horton. I am a commercial arbitrator. I'm based in Toronto, but I do commercial arbitrations both internationally and domestically across Canada. And quite a bit of my work involves cross-border commercial arbitration between Canada and the United States. If I had to pick one overarching trend in commercial arbitration, I would pick the impact of the baby boomer generation. For good and for bad, the baby boomer generation of lawyers became quite interested in arbitration towards the latter part of their careers when they became interested in being arbitrators after they retired from their normal jobs, either on the bench or in large firms and so on. So there started to be an influx of people of my generation into arbitration, starting, I would say, about 10 or 15 years ago. And that's been great because it has increased the interest in arbitration and it's increased the supply of capable arbitrators for commercial disputes, so parties don't have to be concerned about finding qualified arbitrators. The problem with it is that most of the members of the baby boomer generation, as with myself, come to arbitration from a counsel background or a court litigation background, whether they're judges or senior counsel in that system. And they come to arbitration with those prejudices. So what ends up happening is, rather than arbitration being a distinct alternative to court litigation, it starts to mirror court litigation. Internationally, the effect of this is the plague of due process, where we have counsel who insist that unless their rights in court litigation are replicated in arbitration, they lack due process. And of course, there's the implied threat that it will be reviewable in court. I'm sure business people are baffled at times when they see that arbitration really is just a litigation in a private forum and takes as long and involves the same kind of acrimony between counsel and so on as arbitration. But what we're trying to achieve in arbitration is a distinctly efficient procedure. My approach is to assume that in most business cases, it's of value to the parties to have a resolution, full, final, and fair resolution, within a period of about 6 months to a year. We set the arbitration procedures with that goal in mind, and it's surprising how achievable that goal is if you do have an understanding of what arbitration procedures can look like, distinct from court proceedings. Apart from the work I do as an arbitrator, I'm very active in a number of areas where I feel effort is needed in order to create a more conducive environment for arbitration, commercial arbitration in particular, to succeed. One area is education of practitioners, and in Toronto we have a course for lawyers, which is a very substantial course and has been at this point taken by over 40 lawyers. We also have had an education course for our judges, which I've helped to put together and teach. And we're very actively involved in updating arbitration laws. Recently, Ontario passed a new International Commercial Arbitration Act to adopt the recent model law changes, and we're currently working on changes to the Domestic Act as well.